Thank you so much for that introduction. Really happy to be here. Really happy to be part of MNLU. Bombay and Maharashtra is my hometown, is my home for me. So I'm really happy to be back. I'm really happy. I'm looking forward and excited to sort of see what kind of policy ideas everybody has for the presentation today. And thank you for having me.
Thank you, sir. I would like to take this moment to notify all the participants of the rules for the paper presentation. Each presenter will get 10 minutes to present their policy, and they can share their screens to present any presentation or relevant document that they shall have. So shall we commence with the first presentation?
Yes, please.
Certainly. So I would like to call upon the first presenter, that is Dr. Jyoti Shetty from Ferodia Law College, Pune.
Yes. Wait a minute.
Also, just an additional notification. The time that is remaining will be communicated through the chat box. So we will be giving a notification on 5 minutes left, 2 minutes left, and 1 minute left. Is there something, so would you like a different setup or does that work?
No, this works very well. This works very well.
Shall I start?
Yes, please.
Oh. Good afternoon, everybody. Good afternoon, sir. I am Dr. Jyoti Shetty, and my topic is a comparative study of awareness and wait a minute, slide is not good.
Sir, we are pausing the time till she reconnects.
No problem.
That works, right?
Yeah, absolutely. No
Thank you.
Okay, sorry. This is my title, A Comparative Study of Awareness and Implementation of POSH Act 2013 in Higher Educational Institution. And for this one, there is some problem, I think. The slides are not going next.
You may proceed without the slides if you'd be more comfortable that way.
Okay. Okay, so yes.
Doctor, I do have your paper in front of me, so if you are feeling comfortable, we can go ahead.
Okay, sir. Okay, fine. Yeah. So this is the title of my paper, and this is empirical. The paper is based on the empirical study, and background. The first one to check that is the awareness related to the POSH Act 2013, and second one to analyze the implementation measures of the POSH Act in the higher educational institution. Now, for this one, I have made, for this study only, I have made four. That is the female faculties and female students, then female male faculty, female faculties and female means likewise. I just want to do a comparison between the four groups of the respondent. Here, this is the, it shows the concept of the sexual harassment, all these ingredients included in the sexual harassment. And very interesting is that for the concept of the aggravated woman, not only the working, but also the student, even the person or the lady who is visiting the place also come under the aggravated woman. There are two kinds of the sexual harassment. That is the quid pro quo. That means something in return, means the person can given or ask for the given favors for the sexual favors in exchange. And second one, that is a hostile work environment. Suppose the lady is not given the that kind of cooperation, then the male person can make the hostile environment at the workplace. So this is about the concept. Now there are only two hypotheses. The first one, there is significant difference regarding the awareness about the POSH Act between male-female faculties. Second group, the male-female students. Third group is of male faculties and male students. And fourth group is the female faculties and female students. Even the second hypothesis, the point is significant difference regarding the opinions about the implementation of the POSH Act. Now, for this research, I have adopted a simple random sampling, and for that, the data collection is through the primary data as well as the secondary data. And I have taken 100 respondents, 25 from each group, and the quantity is more than 30, so that the t-test is used for the testing of hypothesis. Now, actually, in my paper, there are 8 tables included, but for the sake of presentation, I have chosen 2 tables from the awareness and 2 tables for the implementation. The first table, as you can see on a screen, it is about the awareness of the POSH Act. And here we can see that there is a significant difference between the female faculties and female students. Actually, this legislation is meant for the female students and female faculties, but most of them unaware about this act. The second table, it talks about the awareness about the internal committee. Now, internal committee is an executing body. Our implementation must be implemented through this internal committee only. Then the awareness about the internal committee, here we can see even there is a significant difference about the knowledge or awareness about the internal committee among the female faculties and female students also. So this is about the awareness. Now the table 3 talks about the information about the board poster of the IC in the institution. Now this is a mandatory that to display the boards and posters on the in educational institutions or the colleges, but there are the certain things they are not up to date, or the numbers are given are not in or they are not working. So there are so many things I undergo with this things, and for that purpose or for my study, here we can see that the difference is significant. I just want to mention one very interesting is that most of the faculties know about this fact that the showing posters and boards relating to the point is very important one, but the students unaware about this. So that you can see here the difference is very significant. And the next table I have chosen for the presentation, that is the awareness program in the institution. It is a mandatory to show or to give the knowledge about this POSH Act through the workshops or seminars or the conferences, but the active participation of the students or faculties is very less one. So that here we can see the significant difference about this awareness programs here. Now, apart from this, I just want to mention, because this is the empirical study, there are certain observations, even I followed some interview method for the same. Here, there is the, suppose there is a workshop for the awareness program, they are restricted the entry for only girls, means females, means it is only for the female student, so that it is such action lead to the failure. in achieving the goals of the POSH Act. Even there are the certain things, most of the times, we suppose one convinced that the maintained register of the internal committee, it is only for the sake of NAC committee. So they are taken the signatures of the members on the meeting register afterwards, or they are taken backdated signs from the members. Even they are preferred to compromise the matters only for the sake of the goodwill of the institutions. So it is all about, or the observations are like that. Even they are, suppose the researcher wants to get the information about the students, they are restricted the students, they are just given the information prior to filling the questionnaire. So all of these are the observation relating to the study. Now there are, these are the paper cuttings where it clearly shows that first one, it is displayed in लोकमत, तब्बल 508 कार्यालयात विशाखा समितीच नाही. देन विशाखा समितीबाबत शाळाच अनभिज्ञ. इवन Indian Express also highlighted our internal complaint committees in educational institutions serving their purpose. So it is at a very crucial time. Even there is enactment for last 10 years, but what is the result of that? And for the to suggest, means to overcome from this situation, researcher has suggested one model, that is the triple A model: the awareness, then the application, and action. Now, what is that? It is awareness. The person can, even the educational institution can include value education, sex education in the higher educational institution, even given a knowledge of law to all streams. Then the celebration of the gender sensitization way in the higher educational institution, even in local and a very simple students. For the sake of application, there must be the mandatory attendance to the awareness programs. There must be the classroom and e-learning courses for the sake of the enactment or awareness of the POSH Act. Even short and engaging videos on the websites. Even there should be the counseling centers at the very primary level. It should be provided to the student. There is one question in my questionnaire relating to the counseling center. Most of the students don't know about this counseling center relating to the POSH Act. Then there must be the training module and the case studies methods. Why? Because it is meant for the members of the internal committee, because they don't know how to handle the cases relating to the sexual harassment. So they are just gossiping at the time of meeting. It should not be happen. So that for them, training modules should be provided and under the application. Then the action, deterrent punishment should be there. And because the suppose the student getting the knowledge, there are these certain deterrent punishment, they are not, even the others will not dare to do such a things again. Even such a cases must be handled.
Exceeded your time limit. I'm sorry. Could you kindly just
Yes, only two minutes.
That is at the chair's discretion, ma'am.
Yes, ma'am.
Okay.
I think you can wrap it up. I understood the AAA model.
Only two minutes, sir. Yeah.
Sure.
And the under action, the cases must be handled without the political burden. Even there are the certain value-added courses, even government SWAYAM online courses. It should be enacted or implemented in the educational institution. To conclude, I just want to say that is the responsibility, awareness as well as implementation. It is a primary responsibility of the educational institution. Even in the Rishi Malhotra versus Union of India, making of law is not only the solution to combat with the crime, its implementation is equally important. So that the proper application of the AAA is the very important one to avoid such undesirable incident. And these are certain efforts which such as do the awareness relating to the POSH Act during the study. And even the researcher has suggested one value-added course for the sake of overcome from this one. And these are the objectives over even this is a course designing. And nowadays it is very essential for the under the new educational policy. Thank you, sir, for giving me time. Thank you very much.
Thank you, ma'am. I don't think I have any questions. We can probably move on.
Certainly, sir. So with that, I would like to call upon the next presenters, Shikha Sehrawat and Dr. Daksha Sharma from Bennett University. Shikha, can you hear me?
Yes, yes. Just wait a second, just.
Yeah, sure.
Are you be able to see my screen?
Yes, it's visible.
Okay. Shall I start?
Please give me 30 seconds. Yes, please.
Thank you. Good afternoon to all the presenters and chairperson. I'm Shikha Sherawat, along with Dr. Daksha Sharma from Bennett University. And my topic is a comprehensive examination of domestic violence legislation in India, exploring the concept of gender neutrality. First of all, let me introduce you all what we are going to see further in this research. This is purely based on doctrinal research, and this paper aims to investigate domestic violence laws in India from the viewpoint of gender specificity. The authors undertake an in-depth study of gender neutrality and proposes various approaches for achieving it. The purpose of this article is to conduct a comprehensive examination of the necessity to introduce suitable changes in the legislation for making it gender neutral. This research paper aims to enhance understanding of the precise concept of gender neutrality. This paper offers a thorough examination of the existing legislation concerning domestic violence in India, adopting an unbiased perspective towards gender neutral laws. This paper explored the historical concept of gender-specific legislation and its evolution, aiming to assess the significance of gender neutrality in laws and policies to foster a welcoming and accepting society for all individuals, irrespective of their gender. Let me introduce you all to my topic. So, law and society are interconnected with laws. Wait. Laws in society are interconnected with laws in India and other countries enacted to protect. However, traditional gender roles persist, with men often not being treated equally. Historically, women were the only victims of violence, but modernization and equitable treatment requires law to change society's expectations. The refusal of Indian... wait a second. The refusal of Indian government to extend gender-specific protection to men exacerbates issue of underreporting and perpetuates societal norms that overlook male victims, highlighting the need for laws to adapt to modern societal dynamics and provide equitable protection for all genders. The Constitution of India promises justice for all individuals, yet the lack of legal recourse for men facing harassment and marital conflict highlights a gap in gender-based protection, contradicting principle of equality and justice. While the fundamental rights like Article 14, 15, 19, 21 are enriched in our constitution, legislative statutes such as IPC 498A and the Protection of Women for Domestic Violence Act 2005 manipulate these rights, hindering societal well-being and perpetuating gender bias. While the Indian Constitution pledges equality and prohibit discrimination, legislative statutes like IPC 498A and Domestic Violence Act primarily protect women, hindering societal well-being. In today's evolving society, where gender equality is emphasized, legal provisions remain influenced by the patriarchal norms, neglecting the reality of women perpetrating violence against men. So now let me introduce you all that how domestic violence legislation has came in India. Firstly, the Dowry Prohibition Act was enacted in 1961, making the practices of giving and receiving dowry illegal. That failed to effectively suppress the practice of dowry. The Dowry Prohibition Amendment Act 1984 and 86 were later approved by the Indian Parliament, although their effect was essentially the same as that of 1961 Act. The effort to prohibit dowry-related domestic abuse culminated in the enactment of Criminal Law Second Amendment Act 1983, which added 498A to the Indian Penal Code. According to this law, any husband or his family member who inflicts cruelty on his wife may face a criminal fine and imprisonment. In 1986, Section 304B was inserted to the IPC, introducing the new offense of dowry death. This clause renders women's spouse and in-laws legally liable for the death as a consequence of any burn or other harm sustained under suspicious circumstances within 7 years of marriage. 498A covers domestic abuse against women. 498 covers cruelty against women. However, 304 applies to dowry death. Only married women experience spouse or family abuse can get remedy under both laws. Thus, live-in and other non-matrimonial relationship violence is excluded. These laws do not offer Indian women with legal remedies like injunctions, protection order, interim relief shelter, or monetary redress. These regulations also do not criminalize non-dowry related physical and mental abuse. In 2005, the Parliament passed the Protection of Women from Domestic Violence Act, a law that protects women from various forms of violence, including physical, sexual, verbal, economic abuse, etc.
If you don't mind, can we go to directly to the analysis, or rather the conclusion? Because I'm aware of what is the meaning of gender neutrality. We could directly go probably to the critical study.
So so this is the critical study of domestic protection of women from domestic violence act. So this act offers legal recourse to female victims, providing injunctions, protective order, and criminal penalties. However, criticism arises due to its exclusive focus on female victims, as the name of the act only tells us that it is provided to women only. The act defines respondent as an adult male, reflecting bias against males as perpetrators, which is defined under Section 2Q. The term aggrieved person exclusively focuses on, which is defined on women, which is defined under Section 2, subclause A, omitting male and LGBTQ victims of domestic abuse, presenting an inaccurate depiction of domestic violence. The Act provides protection to women in various forms of domestic relationships, including marriage, adoption, regardless of their status, covering all forms of abuse, which is defined under Section 2, subclause F. Domestic violence, the term domestic violence is defined under Section 3 of the Act. The constitutionality of this Act was challenged on basis of gender specificity by Delhi High Court, which held its validity, asserting that its focus on women was justified due to the rarity of male victims and act intent. Therefore, the need for parliamentary protection in such circumstances is unnecessary and unjustified. The Act defines a respondent as any male adult who has been or is now in a domestic relationship with the aggrieved person. The court ruled that the gender-specific aspect of the Act was a legitimate characterization given the Act intent and purpose, and the Act was thus constitutional. This was held in Aruna Pramod Shah versus Union of India. Later, the Madhya Pradesh High Court ruled that seeking relief under the protection order requires an application of proceeding against an adult male person. Failure to comply is punishable, and a complaint can only be filed against an adult male who hasn't followed the order. The Indian legislation clarified the definition of respondent by including the accused men female relatives, which contradict the legislation intention. This is defined in Jagdant Sharma versus Alka Sharma. Later, the Supreme Court ruled that the Bombay High Court ruling on definition respondent under the Act should include a relative of the husband or male partner, allowing women to file claim against female relative of their male partners, despite previous authorities limited interpretation of the term respondent. Section 18 of the Act allows magistrate to issue prohibitory orders in cases of domestic violence, prohibiting male perpetrators from entering a share household or operating bank accounts and depriving them to access their own homes. Section 31 of the Act criminalizes the violation of an interim order, enabling the female petitioner to easily obtain protection order and potentially press criminal charges against respondent.
Ma'am, could we rush to the conclusion, please?
Okay.
Thank you.
So, in this conclusions and suggestions, men are still underreported in domestic violence cases, largely due to a patriarchal society and there is a stereotypical thinking that only women can be the victims and male can be the perpetrators. In India, there are few laws protecting men offenses, and people still believe women cannot be the perpetrators. To address this issue, the legislature should create gender neutral laws, increase awareness of helpline numbers for male victims, and take violence allegations seriously. Mental health should not be addressed, and stereotype surrounding domestic violence should be broken. Effective legislation changes, public awareness campaigns, and dismantling stereotypes are crucial for positive change in the society. The government should collect reliable statistics on domestic violence abuse, including false complaint, police failures, and extortion. This will help create more effective legislation and deflate conservative opposition. Discipline measures should be.
You exceeded your time.
I
Okay.
think, yeah, I have one quick question.
Yes, sir.
While I think the conclusion revolves around the idea about
Gender neutral laws.
yeah, so it's more, in my opinion, please correct me if I'm wrong.
Yes,
It's more of the opinion that it's not gender neutral,
sir.
and it draws from the fact that it's patriarchal.
Yes, sir.
While that's one side of the coin, the other side of the coin is that if you look at the intent and the objective of the legislation, it is a protection of women from domestic violence.
Yes,
right?
sir. Yes.
So on one hand, you cannot say it is gender biased, while at the other time you cannot, you say that, oh, it is for a particular section of the society, whether it's that section is defined by race, religion, caste, ideology, sex, whatever.
Yes,
Right?
sir.
So if you look at our test of Article 14, if there is a test which is specifically for the nexus to the object, it seems to be a little hypocritical to say that it's sort of gender biased, while at the same time it's for a particular section.
Yes, sir.
What are your views on that?
Sir, I think that this it's not gender, like it's more towards the female, women are more protected by this act, and the males are like behind this act.
Correct,
Actually,
but is it that by design?
yes, sir.
So probably the suggestion that can come out of this could be a law for the other part of the society or another section of the society which can be categorized as
Yes,
male.
sir. Along with women, men should also be protected. That's what I'm saying. I'm not saying that only women are the victims and the men are the victim. I'm saying just both should both the parties should be given equal rights.
Okay, good. That was a question. Thank you.
So
Thank you.
some of the other participants have questions as well. So it is at your discretion whether or not those
I
questions will
don't
be
think we
entertained.
have time for it right now, so we can probably go to the next participant.
All right, so
Thank you.
so please let me know whenever we may begin with the next presenter.
Yeah, why don't you start displaying the
Yeah.
presentation?
Yes, so certainly. So I would like to call upon the next presenter, that is Dr. Finita Roy from OP Jindal Global University.
Okay, are you able to see my slide?
Yes, it's visible.
Okay. So how do I go to the slideshow?
Yes.
Okay, yeah, I think yeah, slideshow. 1 minute. Just a second. Okay, I hope all of you are able to see my slides. So, warm good afternoon, and I'm honored to be given this opportunity to present on the topic addressing the digital inclusion gap, empowering women and girls with disability through assistive technology and inclusive design. So, with over 52 billion unique mobile subscribers globally, opportunity for our societies to be digitally connected are ever expanding. Mobile phones are the primary and often only means of digital communication, internet access for many people in the world, and digital access has incredible potential to transform lives and empower people by providing a platform for sharing and accessing information, connecting to a diverse range of services and linking people across the world. Ensuring that everyone is digitally included supports the achievement of the sustainable development goals and ensures existing inequalities are not impaired as connectivity becomes increasingly important for us. So, however, certain segments of the population tend to face disappropriate barriers to adopting, using, and reaping the full benefits of mobile, including persons with disabilities and especially women with disabilities. So the first step in achieving the digital inclusion for all is measuring the gaps in the mobile access or the digital access and use, which helps to reveal the extent of inequality and generate the knowledge and understanding required to inform and implement the strategic changes. However, the research and data on the digital inclusion of persons with disability is very scarce. So the research objective of this study was to comprehensively analyze and elucidate the multifaceted dimensions of the digital divide experienced by women and girls with disability, to assess the impact of integrating disability inclusive measures and addressing the digital divide in gender programs, focusing on the participation and social economic outcomes of women and girls with disability. The methodology that was used was the research employed a descriptive and analytical approach to examine the dimensions of digital divide for women and girls with disability. So the primary source of data was derived from a comprehensive review of secondary sources, including paper reports, articles, reports from diverse national and international agencies. By adopting a descriptive and analytical method, the research aims to provide a very nuanced understanding of the intricate challenges and depravities within the digital realm. So, why is this study required? Due to the gender inequalities, many women face challenges like inadequate access to healthcare, unsafe working conditions, and gender-based violence. And women are more likely to become disabled in their lifetime than men. Global estimates indicate that 1 in 5 women have a disability compared to 1 in 8 women. So, looking at all these things, we see that, however, the digital divide experienced by women with disabilities is under researched and data is virtually non existent. It is not unusual that developmental efforts focused on gender inequality or disability inclusion are overlooked. How the gender and the disability intersect is actually overlooked. Given the disappropriate intersectional discrimination that women with disabilities face, there is a risk they will continue to be systematically digitally excluded and reap fewer benefits from the mobile and digital aids than any other demographic groups. So what are these gaps that we see and what can we do about it? So the key barriers to women and girls' digital access and use include gender norms, lack of digital literacy, risk of digital harm and affordability. And in some settings, mobile phones and the internet are perceived as a challenge to the traditional social order and a risk to women and girls' reputation or safety, which was actually spoken very clearly by Dr. Soumya Umar today in the morning, where she said that it is really very difficult for women using the cyberspace, and for women with disabilities it becomes even more difficult. So what are the evidence-based recommendations that my paper would like to present is that girls with disabilities can be challenged to reach with digital tools as they face additional barriers to access and use of technology. Gender norms, lack of digital literacy, online safety and security concerns, accessibility and usability challenges, and lack of relevance and affordability all limit the digital access and use for girls with disability. However, careful planning and implementation can overcome all these barriers. So how are we going to overcome it? So it is important to understand that the local disability ecosystem and the MAP stakeholders, this may include schools and organizations supporting people with disabilities, particularly children. Such organizations have a vital capability and influence in the disability community. They can be valuable partners and create awareness of the benefits and the use of digital tools among girls with disability and their parents. As parents and caregivers frequently act as gatekeepers in girls' use of digital devices, and in some instances may provide technical support. Their engagement and understanding of the value of digital tools is important for girls' access and participation. These stakeholders are likely to be vital in facilitating access to girls with disabilities who will need to be consulted in line with inclusive design principles. The next one is it is important that the inclusion of girls with disability is not tokenistic and that they are meaningfully engaged. Facilitators must use positive terminology that does not perpetuate disability stigma and stereotypes. And it is also important that online safety is also a key concern for girls and their parents. So detailed information about safeguarding measures should be provided when obtaining or giving obtaining informed consent from them. And employing only women facilitators for consultations can increase parental comfort about girls' safety. It also fosters more candid and relaxed discussion, particularly if the content is sensitive, such as sexuality. Furthermore, it provides an opportunity to expose girls to women role models working in tech, an area often considered as a male domain. Facilitators already known to girls, such as teachers or leaders from organization for of girls with disabilities or people with disabilities, may make girls feel even more comfortable. So the next one is disability is not homogeneous. So including girls with a variety of impairments is very important. So asking participants for their requirements to take part and tailor consultation approaches and settings to meet their needs. For example, a sign language interpreter may be needed for girls with hearing impairment. Venue selection should access accessibility for girls with physical or virtual disability, and considering whether transport assistance or access to reasonable and accessible accommodation is required is also very, very crucial. So moving on to the next one, seeking advice for those with technical advice, expertise in content with persons with disability, especially representation from organization of persons with disabilities. For example, creating content related to hygiene is very important to address the additional barriers faced by girls with disabilities. So, for example, easy to read text and alternative media are important not only for girls with intellectual impairment, but also for girls with lower level of literacy. And the next one is to look for opportunities, investing. Look for opportunities to support digital literacy programs for women and girls with disabilities. These initiatives will not only empower potential users with the skills to use digital tools, but will also provide an opportunity to raise awareness and increase the use of the digital platforms. And finally, since disability reflects the interaction between the features of a person and their setting, digital development can effectively reduce or remove barriers to participation in the digital realm and empower girls with connection and information, which will be taken into consideration when developing digital tools to reach girls with disability and accessing the and using the platforms, digital platforms. So in my conclusion, I would like to say that recognizing the digital challenges faced by women with disabilities is crucial for fostering inclusivity in the modern age. By understanding the unique needs, preferences, and obstacles in utilizing digital tools, we can dispel the misconception of lower computer literacy through inclusive design approaches. The EU Gender Action Plan 3 provides a framework to enhance gender equality, emphasizing the importance of disability inclusive approach. So engaging women with disabilities in the design process is very crucial. Ensuring their voices are heard and digital information accesses gaps are closed is the need of the hour. So as we work towards a more inclusive digital landscape, the convergence of the gender and disability considerations is very important. For the advancement of the human rights and the socio-economic outcomes for women and girls with disability. So thank you. So a woman with disability needs are not very special, but it might be very different, but the needs are always the same. So this is what I would like to say about my paper. And this is
I'll just like to say that this is a topic which is a lot more closer to home for me. As somebody
okay.
on the spectrum and somebody who does a lot of pro bono disabilities work, uh, uh, these insights have been something that I have been writing upon and reading upon for the last good 5-8 years.
Okay.
While whatever you have covered is intricate, if I may give a little bit of a feedback or sort of just lay down my thoughts on it, is that there are two things probably you could explore further to develop this.
Okay.
Dr. Haben Gurma is a leading disabilities lawyer. She is somebody who is who is differently abled and is from Harvard Law, who does a lot of work in this area, especially in ICT and developing digital frameworks which are friendlier for everybody. She does a lot of great work, and her work is really impactful. So probably you could have a look at the jurisprudence or some ideas that she has developed.
Okay.
Apart from that, what I felt this presentation could have incorporated, probably,
Yes.
which is again just a thought, is the government of India has a very detailed ICT
Okay.
on how websites, apps, and APIs are to be developed, keeping in mind how they are supposed to be friendlier. There is an
Okay.
entire framework that exists, and it's a guideline that exists.
Okay.
And what you could probably explore is take the presentation that exists as on today, and probably move it in that direction. But again, I
Okay.
come from a lot of a legal sort of a background to it. And what will be really interesting to see is sort of a behavioral science way about it.
Yes. Yes.
So probably see how, I don't know, how anchors work, how it could be friendlier. I have very recently written a book chapter on the same, so I'm a little aware
Okay. Okay.
that. But yeah, you could probably explore sort of the guidelines and the ecosystem that exists the way it is today and incorporate it. I think that'll be a great read then.
Exactly. Thank you very much. I appreciate the suggestions that come up my way. But as you have told me, I am not from the law background. I am a psychologist, and my paper has actually dealt with only the behavioral aspect. But I appreciate the suggestions, and I hope I will be able to incorporate that, and I will surely keep this in mind. Thank you very much. Thank you, Mr.
Thank you, Dr.
Dr.
Ravi.
Thank you for that. So, if I may call upon the next presenter and they may start setting up.
Yeah, they can start setting up. Just give me a minute, please.
Yes, of course, sir. So, Shivangi Shivi from Chanakya National Law University, you may set up your presentation and we shall begin whenever the chair deems it fit.
Okay, okay.
Yeah, I think we can begin. I just don't have the presentation or the paperwork or something.
Sir, I hope my screen is visible.
Not yet.
Screen is not visible. Which screen? हाँ तो यहाँ से Sir, I'm not able to share my screen. Shall I start without sharing my presentation?
Ritika, could you assist or maybe we could circle back to Shivangi later?
Ask her to send us.
Yeah, that we can do that. Shivangi, if you'd be okay with it, we can have your presentation at the end.
Okay, okay. Okay, thank you.
Great.
Thank you.
So with that, I think we can call upon Bonnie Ghosh from Sandeep University, Nashik.
Yes, ma'am. Am I audible?
Yes.
Okay, ma'am, give me 1 minute to share my screen.
Yes, ma'am, certainly.
Okay, yeah. So, ma'am, is it visible to you?
Yes, it's visible.
Okay, ma'am, give me just 1 minute. Yes, ma'am. So, just once again, am I audible to all of you?
Yes, you're audible.
Okay, yeah, thank you. This is Bonnie Ghosh, and thank you for giving me the opportunity to present over here. And today I will be presenting on the topic called Public Perceptions of Gendered Deepfakes and the Reinforcement of Gendered Stereotypes, and it is basically a sociological perspective. And I, Bonnie Ghosh, Assistant Professor, and currently I'm working in School of Law, Sandeep University. So first, I would like to focus on like the what is deepfake and what is the like where we have came up with the concept called deepfake technology. So basically, the emergence of deepfake technology is like distinguished by its capacity to produce highly realistic synthetic method, and it has introduced a new era of digital manipulation. And if all the audience over here can remember, like recently, 2 3 months back, we have like huge like news coverage on Miss Rashmika Mandana's case. And it was really like initially it was like public perception was it was real. And basically, it is the gendered deepfake. And I will come to the point what is deepfake all about within a minute. And it is basically the utilization of artificial intelligence, in short, that we call AI, to modify the gender-specific traits of humans. And for this reason, it reinforces the conventional preconception. So basically, it is widely, if we talk about what is deepfake, so it is the widely used method for what we can say facial manipulation. And their illicit application currently provides significant risks to the what I want to mention over here. That is the such societal stability, national security, and also like most importantly, personal reputation. And over here, I would like to focus on specifically the theme of the MNLU Mumbai summit regarding this gendered dimension of cyber harassment. And deepfake pornography is basically like disproportionately targets women. And like obviously, if it is targeting women, it is like frequently disseminating it without their consent. And research shows that according to this like technology experts, the research shows like over 90% of the deepfake films available on the internet are of a sexual nature, and the majority featuring women. And what we can say, following one of the experts in this deepfake technology, generative AI will unfortunately amplify online harassment and obviously malicious content, and women are the first to experience its negative effect. And over here, I want to again mention about Ms. Rashmika Mandana, Katrina Kaif, or Kajol, and also we have cases of Aishwarya Rai and Alia Bhatt. So all of them are celebrities, and obviously, if celebrities are getting attacked by this cyber harassment or gender dimension of the cyber harassment, look, where like we, the lay people or the regular women, we belong to over here throughout the world. So, like what we can say, just give me a moment. Yeah. So, what over here I would like to focus, that is the gender stereotypes, conventions, and expectations around the gender roles. Like what society wants, or what is the expectations around this gender stereotypes. So basically, our country, India, and majority of the countries all over the world, like where the patriarchal nature, patriarchal society is there. Like within a patriarchal society, a female, basically a female's body becomes a focal point for conflict and assertions. And the female body is perceived as a representation of femininity. And it is like femininity is influenced by what I have found in my research, cultural norms, and shaped by societal influence and subject to individual agency. And the repercussion of digital gender-based violence, like this gender deepfake, the violence can beyond the realm of internet. And individuals who fall victim to deepfakes may undergo a state of pervasive unease, accompanied by obviously a feeling of embarrassment, rage, humiliation, and overall social disapproval. And this gender stereotypes establish commonly accepted prejudices regarding specific qualities or traits, and reinforce the belief that each gender and its corresponding behavior is strictly basically binary in this patriarchal society. and any gender behaves in a manner that deviates from societal expectations, what is society is expecting from us, being a female or male, that like it creates discrepancy in the evaluator's perception. So like what we can focus right now, the second bullet point over here, like various socializing agencies. So who are the socializing agencies, and who are the agents of socialization? Like our parents, teachers, peers, or media, literature, religion. Like throughout our life, we are like having the continuous socialization process, and these socialization agents are like playing a like immense role in teaching and reinforcing our gender roles. What's supposed to be your role being a female? What's supposed to be your role being a male? And over here, like it is continuous, like reinforcement of these gender roles. Like you have to be like this because you are a female, and you have to be like that because you are a male. So moving on, what theoretical framework I would like to focus over here? Three theoretical frameworks I would like to focus. First, the feminist perspectives and gender stereotypes. So what basically the feminist perspective says on gender stereotypes, like throughout our lifespan, the primary and secondary socializing agencies are consistently reinforce the notion that females should be primarily characterized by their physical appearance. So I would like to repeat over here, physical appearance. And this benefits men by associating female self-esteem with physical attractiveness rather than genuine accomplishments. Next, moving on, the social constructionism. So what does it say? Like gender is commonly seen by scholars as social construct, implying that it is not inherent but rather a product of cultural and social the conventions. So whatever the society is prescribing for the females. And the last one, that is the symbolic interactionism. And over here, I would like to go through the concept of Charles Horton Coley, like his theory of looking glass self, and which asserts that the individual self-image is mostly shaped by society's impression of them. Now, just straightly, I would like to conclude. That is like the creation of synthetic image. That is we are talking about over here today. That is gendered deepfake. Our films that appear authentic, known as like just I have mentioned, gender deepfake poses a huge danger. Obviously, we all know this celebrity cases like that. And what about the safety or security regarding the social networks we use? And it poses a huge danger to the preservation and reinforcement of existing gendered norms or gender standards. And the perception of understanding the gender defects differ greatly among different demographics group. Like if I am a young person, I might take the gender dimension of this defect differently compared to someone is aged or someone who is senior citizen. He or she might not be aware of that technological advancements or the implementation of the AI. So for my research, what I have found that younger cohorts who tend to possess greater proficiency in digital technology are likely to exhibit a great degree of skepticism and consciousness, where the senior citizens might not. So coming to the point of so how can the safety of women are safeguarded in this era of artificial intelligence? So over here, my suggestion would be like we must have kind of a comprehensive and multifaceted approach, like proper laws and advancements in technology and some educational initiatives. Then we can say digital platforms, including social networks and other websites. Along with the public authorities, they should adopt defect detection technologies and other kind of digital violence identification systems. Then what I would like to mention that it is very crucial to enforce stringent policies and measures to prevent the dissemination of modified content. And lastly, but not least, what is for me is most important, that is the general awareness, or what we can say that some kind of educational programs must have, so that all we are aware of this gender defects or overall defects, and this use of negative impact of this use of AI. So moving on, these are my references, and I would like to have some kind of some questions. And thank you very much for giving me the opportunity to present over here.
Thank you.
Thank
Thank
you.
you. I'm not sure if I have a question, but I definitely have sort of a thought, which is a very interesting. What I thought was very interesting from your conclusion and suggestion
Yes, sir.
is that the way I look at it, it's a vicious circle.
Yes, sir.
It's a gender stereotype that fuels deepfakes, and it's deepfakes that again fuel gender stereotypes. It's a
Right.
vicious circle that goes on,
Yes,
and
sir.
I think that the only way to break it is awareness. Is that the central theme of what you were going for, or is there any other way you would like to suggest to break out of it?
So I absolutely do agree with you. It is a vicious cycle, and honestly speaking, before the case of Miss Rashmika Mandana, I was not aware with this. Instead of like I claim that I am a modern lady, and definitely we would. I suggest the awareness. Through awareness, we can break the vicious cycle, and it must not happen. There must be some kind of safety irrespective of the gender. Cyber security we must have, and awareness is the only. Law and order or stringent policies are there, no doubt, but general awareness must be there.
Right, ma'am. Thank you.
Thank you, sir.
Thank you so much for the presentation, ma'am.
Thank you, ma'am.
Now, I believe the next presenter may set up their presentation, and we can begin whenever sir is ready. So the next presentation will be Chanpreet Kaur from Amity Law School. I believe that they are not in the meeting.
I think we can go to the next presenter and come back.
Yes, so certainly. So the next presenter would be Chayanika Basu.
Am I audible?
Yes, you may set up until sir is ready.
Yes. Is my screen visible?
Yes, it's visible.
Just give me a quick second, please. Yeah, I think we can begin.
A warm good afternoon to the esteemed panel, my fellow participants, and of course to the organizers of the esteemed seminar. I'm Chainika Basu. I'm a research student at Savitribai Phule Pune University, and I'm here to present my topic, which is Beyond the Screen, Exploring the Gendered Realities of Cyber Harassment. Now, of course, this fact is very much known to us that the social networking sites today have become an essential aspect of our lives. It is a sophisticated method of communication and information sharing. So digital platforms are often praised for the equitable chances that it gives to individuals, regardless of their identity and social standing. So today, this presentation shall revolve around the following points, wherein we shall have an idea about the gendered cyber harassment, the different types of it, the reasons behind it, statistics that will discuss the rising trend of the cyber crime against women in India from 2017 to 2021, the cyber laws in India, some of the noted case laws, and of course with the conclusion. Now coming to the fact that what is basically gendered cyber harassment? Now cyber harassment, of course, as from the name it suggests, It is using the digital platform for the purpose of frightening, manipulating, or causing damage to a person, and it surpasses the geographical limitations. And of course, it results in very harmful and widespread effect. Now, in fact, the gendered aspect of it is even more crucial because it is in need of the time that it requires more attention. Because let's all face it, of course, here we are not going against the equality of male or female, but women are more vulnerable to these sort of crimes like sextortion, cyberbullying, morphing as compared to the male counterparts. So, therefore, here we aim to discuss the challenges that are faced by the system and the need to implement some gender sensitive policies in order to arrest the escalating problem. Now, what are the different types of gendered cyber harassment? Of course, the first one is cyber sexual harassment, where the internet is used in order to engage in uninvited and often hostile sexual conduct against a person. It can be in the form of transmission of unwanted sexual messages, unauthorized dissemination of private photographs, act of cyber stalking, engaging in cyber sexual bullying, and so on. Next, let's talk about what is cyber stalking. Now, cyber stalking, it includes tracking an individual's online activities, either by sending the female any sort of mails or keeping a track about the profile, or let's say disturbing her in any of the chat rooms that she is very frequent with. Next, about the cyber pornography. So over here, any men who knowingly sends pornographic material to any lady against her will by email, WhatsApp, or any other electronic medium is a violation of the law. Next, we'll discuss about the cyber defamation. As from the name it suggests, defamation is an act wherein our main intention is to tarnish the image or the reputation of a person. And whenever this sort of act is done through the medium of cyberspace, it is known as cyber defamation. And the worst part about cyber defamation is that if it's in the form of physical, like wherein I'm telling a particular individual, defaming a person, it's mostly confined within a few people. But in case of cyber defamation, it quickly reaches a worldwide viewership thanks to the media, blogs, forums, and other sort of online communication channels. Next is morphing. Well, morphing, as we know, over here, like the photos that are available for girls on different sites like Facebook, Instagram, those are downloaded and it's merged with some of the nude or semi-nude photos, and some sort of a compromising situation is created in the form of a virtual projection wherein the girl faces a sort of how we can put, the girl faces a sort of trauma and a distress, and it hampers her in the long run. Next is email spoofing. Here, it is a deceitful activity where a person sends email with falsified sender address, creating an illusion that it has been sent by someone, whereas the person has not sent it. And finally, it's the trolling. Of course, it's very known to all of us. Any sort of online harassment, we can call it as trolling. And it takes various forms like, hate speech, where you express your mind against any particular thing, for or against. And then there is a group of people who bombards you with those hate messages and character assassinating you. There are threats and intimidation, wherein you express your mind and rape threats come in, or let's say acid attack threats come in, and it creates a sort of fear in the mind of the girl even to step outside her home. Doxing. Doxing is the act of deliberately exposing private details of a female, like her residential address, her contact details, her employment locations. Impersonation, and of course gaslighting, wherein those messages creates a sense of doubt in the girl to such an extent that she starts doubting her own perceptions, emotions, and mental stability. So these are some of the kinds of gendered cyber harassment. Now, let's focus on what are the reasons for this gendered cyber harassment. Like, why are the girls being targeted so much? Now, the reasons mainly revolve around four aspects: the sociological reason, the psychological, lack of awareness, and easy availability and addiction of internet. Now, let's focus on the sociological reason. Now, there are certain facts which we might not like, but it's true. We live in a patriarchal setup. Even till date, parents have the habit of, asking the girls, don't go here, don't go there. It's nothing of putting a restriction, sir. They're just scared because the society is as such. So, and at a teenage or at any other age, we don't like restrictions. So what happens that time, we consider parents as our biggest enemy, and we try to find solace in the outside world. So what we do, we start chatting with different people, and these people, taking advantage of our situation, they try to gather information, and later on they use it against us. Now, what are the psychological reasons? Now, this is a fact known to all of us, that the Indian family structure has gone for a huge transformation. So these days, mostly homemakers who are busy building homes, there are times when, they feel lonely. The husband is busy, children are busy with their lives. So often they enter into the different chat rooms. And the worst part is that they're not even aware most of the time about which site might be vulnerable for them. So as a result of it, this women's isolation and vulnerabilities and dependence on online communication makes them or puts them in the risk of engaging with strangers. Third is the lack of awareness. There are several laws that are available, but the unfortunate part is that there is lack of awareness about the laws, and if something happens to you, what to do. Like the modus operandi of dealing with the offense when you become a victim is often not known to most of the people. So the need of the time is to empower women with the information and skills for digital self-protection. And of course, to make them aware about where to seek help in case of some sort of cybercrime happens. And of course, needless to mention about the addiction of internet. Most of the time, we are so used to being online, chatting, or sharing messages with people, maybe some people known to us. But later on, it often backfires, and these together culminates into something that makes the victim, the women victim, more vulnerable to such situations. Now, here is a statistics that I have discussed regarding the crime against women, the cyber crime against women, wherein from 2017 to 2021, there has been a sharp increase in cases of cyber blackmailing and threatening. In 2017, it was 132. And in 2021, it has reached 200. The source, of course, is the National Crime Records Bureau. Cyber pornography in 2017, it was 271. And now it has reached 1896. Cyber stalking from 555 to now it's 1172. Defamation and morphing in 2017 it was 50 and now it's 276. And creation of fake profile in 2017 it was 147 and now it has reached 225. So the numbers are really alarming. Now let us discuss about the cyber laws in India. Well, there are three laws that renders protection. First is the IPC, the IT Act, and of course, the Indecent Representation of Women Prohibition Act. Now, in IPC, we have Section 354A, 354C, 354D, which provides us protection in case of any sort of such cyber crimes. Now, apart from that, we also get protection under Section 499 of IPC, dealing with defamation, Section 503, making threat to harm someone's reputation, and Section 507 and 509 of IPC. What is Section 509 of IPC? Whenever any person intentionally utters any words or makes sounds or gestures or displays object insulting a woman's modesty, he can be prosecuted under this section. Now, the question might arise, why I'm specifically mentioning Section 509? Because it has a direct reference to a very important case law of Ritu Kohli's case. I'll be coming to that. The next law that we are discussing over here is the Information Technology Act, wherein Section 66C, Section 66E, Section 67, Section 67A and B, it renders us protection, wherein the publishing, transmitting, or facilitating transmission of.
Ma'am,
Yes.
I am sorry to interrupt, but you have exceeded your time. So if you could just wrap it up.
Yeah, quickly, I'll just wrap it
Ms.
up.
Bal, could we go to the conclusions, please? I have your paper in front of you. I've read your next sections. If we can go to the conclusion suggestion, that will be great.
Yes. So quickly, the suggestion that I have regarding the law aspect is that here there are certain situations wherein, like the gap, I'll mainly discuss in conclusion. The IT Act, it mostly discusses about the transmitting, publishing, or capturing of image of the private area of a woman's body. Like it's more on the physical part. The emotional aspect, the damage that it causes because of this activity is unfortunately not covered in the Act. Moreover, in the IT Act, the term is used whoever and any person. So as a result, what happens? Specific concentration on women victim has not been focused upon, which is the need of the time, which should be focused upon. And finally, I have the conclusion saying that mostly the laws have discussed about the physical injury or the any sort of damage that is caused to the women. I think it's high time that more focus should be given on the emotional trauma that a girls go through, and specific legislation should be addressed, or maybe amendments can be made in the existing law to address the issue. Thank you.
Thank you. Is there any correlation that you bring about between the data with respect to cyber incidences that have happened and your conclusion? Is there any way these two aspects get related?
So what I feel is, most of the time, the laws that are made, it's like paper tigers with no claw and teeth. So what is the need of the time? There are laws. There's no doubt about that. But due to the lack of awareness, and it's not only amongst the victims, there is also a lot of negligent part on the part of the police officials while registering complaints. So what happens is that the perpetrators, they have this attitude of, and like getting it too easy, because in forms of since it has no geographical limitations as such, tracing of IP address, I think the perpetrators are one way ahead of the investigating officers. So what I feel is the main reason for the increase in numbers is the lack of awareness, and even if there is awareness, a very lenient approach in dealing with these offenses. That is the time, this is the time it should actually be acted upon. Because being from the professional, I have been a practicing criminal lawyer. So what I have seen is whenever you go to lodge an FIR or anything of that sort, police have a very laid back attitude. They are more interested in taking a GD rather than an FIR. And so, this attitude of leniency, kuch nahi hota beta, aisa aap block kar do profile. What will be your work then? So I think this lack of detrimental approach towards the perpetrators have given them a very easy hand.
It's a bit of a chicken and egg story.
Yeah.
If there are higher number of incidences, then the police are not doing the job. If there are lower number of incidences, the police are not doing the job. So we don't really, we'll never. Stats is something that's a very difficult aspect when it comes to crime, to see
That's true.
whether there's no way of correlating that data. So
That's true. Yeah, I agree with that. But going by the facts and figures, like this is a safe summary that we can draw. So yeah.
Okay, thank you so much.
Thank you so much. Thank you.
Thank you for the presentation. I believe that Shanpreet Kaur has joined us, so we could have that presentation at the end with Shivangi. So right now,
that's convenient.
yes, sir, certainly. We could so now I think we can call upon Anushri Saha from Indian Institute of Legal Studies. And you can just set up your presentation until sir is ready. Is Anushree in the meeting?
I think we can skip her over.
All right. So the next presenters would be Aditya Kalvarsa and Dr. Neeraj Malik.
Yes, ma'am. Good afternoon, everyone.
Hi. You can set up your screen until Sir is ready to begin with your presentation.
Yeah, sure.
Yeah. Thank you.
I think I'm audible and visible.
Yes.
Yeah, thank you. Today I want to present about data privacy law in India, a critical analysis. Now, we all know that the development of the era and dynamism of prism would offer outlook of privateness and fact protection problem in current area. Privacy is something that isn't to interfere to the interest of other. Right? Is turned into a concern of each person due to technological advancement. And it is also emphasis narrowly for safety of fact status safety emphasis person liberty and those person liberties under risk by mean of interference of strangers. Well, a right and inherent and inalienable characteristic of human society have been reduced into a visual and implementation documentation in international and national sphere. Some rights find explicit mention in such document while others are introduced through interpretive tool due to internal linking with such right. Among all those, right to privacy is one of the most important and acceptable personal right. It provides power to individuals snooping from others. Right to privacy find reference in the Universal Declaration of Human Rights and International Covenant of Civil and Political Rights, Convention on the Right of the Child. Right to privacy is the most internal part of human life. When every person is eligible to a personal domain free from unjustified interference or surveillance by the state or other actor, notwithstanding the pervasive recognition of the obligation to protect privacy, the specific content of this right was not fully developed by international human rights protection mechanism. The lack of clear expression of content of this right has contributed to difficulties in its application. Well, if we talk about the concept of data protection, the concept data is taking the important place in worldwide. Gradually, all the nations are embarrassing the concept of data protection and implementation laws regulating the use and abuse of personal information. This terminology, data protection, is derived from German term, and data protection concept is more or less connecting with connecting with enumeration. There are variety. Next हमारा आता है constitutional status. The Constitution of India has some provision like freedom of speech and expression, right to life and personal liberty. These provision has its effect to the right to privacy as a fundamental right. There are a number of cases also which establish the right to privacy as a fundamental right. The conception of this proposition has also connecting with the new dimension of data protection. The linkage between privacy and data protection are interdependent to each other. The right to protection is closely related with information of an individual. The study of constitutional provision to understand the relationship of private explicitly scripted right along with the interpretation accorded by the apex court of the country. It explores the issues of data dealt with under different legislation. As the most important, significant and illuminating discussion is that privacy and data protection has different link to each other. These linkages are shadow of different areas that are interrelated with these design. Like privacy is a concept related to seclusion, solitude, and isolation. Although it is not a synonym with these terms beyond the purely descriptive aspect of privacy, like withdrawal from the company curiosity and influence of others. The right of individual can be acquired naturally, so that the right to privacy has also to attain naturally. Analysis now, without wasting, I want to conclude that the analysis of different themes highlighted the data protection has treated as a right on different perspective. All the subject like right to privacy, right to information, information technology, IPC, corporate affairs in consumer were given special emphasis to aspect the fact of protection as a right and
Ma'am, you're on mute.
sorry. The scope, I want to conclude that the analysis of different theme highlighted data protection has treated as a right on different perspective. All the subject like right to protection, right to information, information technology, and Indian Penal Code were given special emphasis to accept the fact of data protection as a right. The scope of technology day by day increasing to maintain the increasing phenomena. It is requiring strengthening the data protection regime for the protection of individual liberty. Idea to this reserve is to establish right to privacy and data protection right as a fundamental right, and after analysis, it is justified to treat as a right. The awareness about the right-based approach of data protection has to spread worldwide enormously. Thank you. Hello.
Yeah, thank you. What are your views on the new Data Protection Act that India has sort of passed but not enforced yet?
Um, yes, sir, there are a number of provisions in constitution. If we talk about the freedom of speech and expression and right to life and personal liberty, there is given a right that there should be a right to privacy also, and nobody is right to leak any data or
Okay, all right. Thank you. I think we can
thank you.
move on to the next presentation.
Yes, sir, certainly. So I believe the next presenter would be Aparna Jha from Pyramid Foundation.
Yeah, hi. Am I audible and visible?
Yes, you're audible. I think you could set up your your
Yeah,
presentation.
perfect. Perfect. Yeah, sure. Just give me a sec. Yeah, okay. So is it visible?
Yes, it's visible.
Okay, so yeah, hi. My name is Aparna Jha, and I'm currently working as program manager with Pyramid Foundation, and this is part of my master's thesis at IIT Bombay. Though integrity and privacy was not the core part of my analysis, but over the period of time, I realized this is also coming as a important typology while I was trying to analyze the perception of women as stakeholders, and I studied 81 HEIs. Those are of Institute of National Importance, like all the NITs, IITs, and triple ITs. So yeah, this is the content of my presentation, where I will just give a brief introduction, evolution of legal framework, how SHWW Act evolved, and the research methodology, and the problematizing the problem, and the aspect of mistrust of privacy and confidentiality, data analysis, policy imperative, and then I will conclude it. Okay, please You have raised your hand.
So could we please go from an introduction to problematizing the issue,
Yeah,
and
sure,
we can
sure,
just go
sure,
to the
sure.
critical aspects. You work in policy, I work in policy. We know how it works, so you don't have to give me an evolution of the law.
Okay,
We
cool,
can
cool.
just
That works.
problematize
No,
and we can analyze that. That will be great.
yeah, sure, perfect. So actually, basically, I used one Paul Kearney framework. So I mean, I just
I saw that.
contextualized it. So
I saw that.
okay, cool. So do I need to skip that?
You can go about your way, but the fun aspect is that it will be the problematization of the
Okay,
situation.
cool, 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 cool. Yeah. So basically, I compared this Vishaka guideline and SSWW Act on like what are the areas like the applicability, ambiguity, scope, obligation, redressal. All these were one of the major impediments which led to the formulation and promulgation of SHWW Act 2013 as we see it. So basically, if we talk about, I exercised my positionality and experiences to understand and comprehend the issue of sexual harassment from more than personal. I mean, I'm sorry, but many of the women must have experienced it. So did I, and this somewhat accentuated me to further get into this aspect. So I used Sandra Harding's standpoint theory. According to Harding, the perspective produced by less privileged social positions are more likely to be less partial and less distorted, and that those produced by other social positions. So basically, I use triangulation method to understand different, like I use three frameworks to understand it, although I'm not using any of it here because privacy was, as I said, that it was not a part of my analysis. It emerged out. So I got the response from 238 responses, which I got from students and alumni and also female faculties, out of which 3.8% were alumni, 3.4% responses were from research assistants, and 24 responses were from faculties and non-teaching staffs. And as I said, I did it in IIT, NITs, and triple ITs. Yeah, so as far as problematizing the problem is concerned, underreporting of sexual harassment is one of the major issue, and the reason what came out of those lived experiences are fear of retaliation, societal retaliation, lack of trust in the institutional mechanism, the internal complaint committee, which is mandated to proceed ahead with it, but they don't have confidence on it, like the respondents, I mean stakeholders. And that is giving rise to the sexual harassment, despite we have IC, which says that there is a continuous rise in gender parity index, but this is also a very paradoxical situation where we see that many of the these doesn't go to like it is not being reported. So wait a second. So yeah, so mistrust on privacy and confidentiality is one of the major thing, and present survey findings shows that mistrust in institutional mechanism, and there is a fear of privacy breaches. Testimonies, whatever we have recorded so far, highlights the impact of privacy concerns on reporting. So basically, I received 240 around responses, out of which when I asked about ICC, I received only 5 responses, which says like when I asked this question, do you think that ICC treated your complaint with utmost confidentiality? Most of them said no. And and when I asked about how was the reaction of people in the campus towards you after lodging the complaint, I got the response which says that their social life was completely changed after lodging the complaint. Many people started distancing themselves from those who have reported the complaint. Many stare at me when I walk in the campus. So these were very disturbing, testimonies which we received. As far as policy imperatives are concerned, we need to have a comprehensive policy measures to address sexual harassment in higher educational institution, credibility, openness, and accountability. I'm trying to come up with a framework where I can, make this a trinity of credibility, openness, and accountability framework. And this is still, this is in progress because privacy is one of the thing which emerged out. It was not intentional. So yeah, this I'm not in the position to justify it, but yeah, what I feel is criminalization of privacy violation might strengthen the reporting mechanism, as far as my understanding is concerned about it. And we need to build trust to ensure privacy in addressing sexual harassment, as our study found a huge gap between de jure and de facto, between actual incidents and the reported incidents of harassment. We need to have a very collaborative efforts from institution, policymakers, and stakeholders, and of course, criminalization of mishandling. This is it. This is all I have at this point of time. Yeah, thank you.
Thank you. I have a bunch of questions.
Yeah.
So if you look at the aspect of criminalization of mishandling, if you
Yeah.
look at the theories of punishment, it is very interesting because sometimes it's not a proportional relationship between. Sometimes when you try to overtly criminalize a certain behavior, uh, it does not necessarily lead to a higher uh, number of incidents reporting, or it does not uh, lead to uh, you know an understanding of what the issue is. It's not that directly proportional. So you mishandling might not. I don't know. So what's your thought? Is criminalization of mishandling, is that the best way, or would it have a more effective policy solution to it?
So as I said, this is a very minuscule aspect of it. ICC, my research work was focused more on understanding the mechanism, the power asymmetry. So when you talk about ICC, what I feel is many of their acts, I mean, ad hocism is very much prevalent in these higher educational institution. So I have many such cases, which perhaps I'm not, since the session is recorded. In fact, I have so many evidences where you will be shocked to know that ICC has recommended, but there was an ad hoc committee set up by directors to, sabotage whatever that ICC has done. And like these things, so perhaps criminalization perhaps could be one of the way, what I feel. And many of their works go unrecorded and unreported. So this is what my understanding is
Also, can
concerned
you go
as.
back to your data slide?
Yeah, sure.
Sorry. How was the reaction of people on the campus? Question 2 and question 4 to me seems same. They can be put in the same bucket, and
Okay,
therefore
cool.
that will be the largest bar, right? That will be the highest data set, because many stare at me when I walk in the campus is also an aspect of social life, in my opinion, and
Yeah.
therefore if both of them are clubbed, that becomes 80%, right? So
Yeah,
that
I got
becomes
it.
that is something that then pivots the problem. It changes from people distancing themselves to how social life is affected by registering an ICC, right? So maybe you would like to look at it like that.
Yeah,
And
cool. Yeah, I'm keeping it. Yeah. What else? So any
yeah,
suggestion? I mean, it
looks
is.
great. I think it's still a little bit of work in progress, and you're on to something. I would
Yes,
like
sir.
if there's a framework that's already developed, or it's still in progress, how it's going.
So basically, as I said, I have got a lot of responses, but I just use these two data here. But I mean, basically, I'm using Carol Bacci's framework and also third dimensionality of power, Luke's third dimensionality of power. Maybe I would share, maybe I can drop my work to your email ID, and we'll talk about it, because this is
Sure.
I'm simultaneously doing with my current work. So yeah, this is it. And perhaps we'll come up with some good policy frameworks or something.
Sure.
Yeah.
Sounds great. Sounds great. Thank you so
Okay,
much.
thank you. Yeah.
Ritika, can we move to the next presenter, please?
Yes, so certainly. I believe the next presenter is Professor S.D. Kulkarni and Renuka Ramachandran. Are they here?
Yeah, I'm present. Just give me a second.
Wonderful. So you can set it.
Is the screen visible to everybody?
Yes, it's visible.
All right.
You'll
Feel
have
free to
give me a
start the
minute,
timer
please.
once I move to the next slide. Yeah,
just
please take
give
it.
me a minute, please. Yes, please. We could begin.
Please feel free to start the timer once I move to the next slide. Good afternoon, everybody. My name is Renuka Ramachandran, and I'm a final year student of the 3-year LLB program at Symbiosis Pune. And with me is Professor Dr. Shirish Kulkarni, who's an assistant professor at the same university. And while he's not here with me right now, we're extremely glad to be part of this conference and very happy to present our exploratory doctoral research on gender-informed cyber disputes, leveraging technology in online dispute resolution for equitable resolution. Now, through the course of the presentation, we shall first understand the terrain, understand what you're looking at, take a look at the literature available on the matter, and then we will move on to understand the interplay between gender-sensitive cyber disputes and ODR. Then we should also look at global conventions that support the use of ODR in the resolution of gender-sensitive cyber disputes. And then we shall move on to understand the Indian legal framework on the same, and shall finally proceed to understanding why and how ODR can be leveraged as a preferred avenue for resolving gender-informed cyber disputes, and then take a gander at maybe a few recommendations as to how we can implement this into our ADR framework effectively. Now, in a rapidly evolving digital landscape where technology technically permeates every aspect of our lives, cyberspace presents both incredible opportunities as well as daunting challenges. Now, one pressing issue is the prevalence of gender-informed cyber disputes, highlighting the complex intersection of technology, identity, and justice. Now, particularly vulnerable are marginalized communities, including women and LGBTQ plus individuals, who often face very disproportionate levels of online harassment and abuse. Now, traditional legal avenues struggle to address these modern challenges, leaving victims feeling disempowered and marginalized. Now, the adversarial nature of litigation often compounds their trauma, deterring many from seeking justice. However, ADR and ODR platforms prioritize inclusivity, accessibility, and empowerment, providing victims with tailored interventions and pathways to redressal. Moreover, ADR and ODR also promote transparency, accountability, and collaboration, thereby leveraging innovative technologies to enhance dispute resolution processes. Now, by centering the needs of victims and fostering collaboration, these platforms pave the way for safer and more equitable online environments. So, in essence, basically, ADR and ODR represent a paradigm shift towards a more responsive and inclusive approach to justice in this digital age. And by providing a comprehensive support and promoting reconciliation, we offer hope for a future where online spaces are characterized by empathy, respect, and dignity for all. Now, in the landscape of digital interaction, gender-based interpersonal cybercrime emerges as a significant concern, with women often bearing the brunt of its impact. Now, this encompasses various forms of online behavior that target individuals based on their gender, resulting in harm across cultural, socioeconomic, and demographic contexts. Now, the term gender-based violence extends from offline to online spaces, encompassing physical, sexual, and emotional harm inflicted on individuals due to their gender. Now, within the digital realm itself, technology-facilitated sexual violence encompasses a range of harmful behaviors perpetrated through information and communication technology. And all of this includes cyberstalking, image-based sexual abuse, online sexual harassment, etc. And these behaviors are positioned along a continuum of violence, blurring the boundaries between online and offline trends. Now, research underscores the heightened risk women, especially those from marginalized communities, face in experiencing online abuse and harassment. And shocking statistics reveal a significant portion of women experiencing online abuse, ranging from cyber harassment to threats of violence. Now, social media platforms, dating apps, and online forums serve as conduits for such abusive behavior, creating a hostile online environment characterized by threats, derogatory comments, and the dissemination of non-consensual internet imagery. Now, legislative responses to gender-based cybercrimes vary across jurisdictions, with some countries enacting specific laws to criminalize such sexual abuse and cyber harassment. However, challenges still persist in prosecuting perpetrators and addressing the complexities of online abuse within legal frameworks. Now, in the Indonesian context, for example, there are discussions regarding the efficacy of utilizing ADR methods in addressing gender-based cybercrimes. Now, while ADR approaches aims to resolve conflicts outside the traditional legal system, concerns are raised about potential contraventions of existing laws and inadequacies of safeguarding the victim's rights. Now, moving beyond cybercrime, the discussion also touches upon gender dynamics within the cyber criminal community itself. If I remember correctly, Ms. Shikha Sehrawat mentioned this in passing during her presentation as well. While conventional perceptions often depict cyber criminals as predominantly male, there is acknowledgement of the presence of female cyber criminals, albeit in minority. Now, efforts by cybersecurity firms to adopt gender-neutral approaches in their research practices highlights the importance of mitigating this gender bias in criminal investigations. And the digital gender gap that's reflected in statistics on internet access and online activities underscores broader socioeconomic disparities affecting women's involvement in cybercrime. Efforts by international bodies like the Council of Europe, the UN Women, all of these aim to address these issues through gender-responsive approaches and legal reforms, emphasizing the integration of gender perspectives into conflict resolution processes and legal frameworks to create inclusive and equitable online environments. So in conclusion, the literature review basically emphasizes the multifaceted nature of gender-based cybercrimes and the urgent need for comprehensive responses encompassing legal reforms, technological interventions, and societal awareness campaigns. Addressing these issues requires concerted efforts from policymakers, law enforcement agencies, technology companies, and civil society organizations to promote online spaces that are inclusive, respectful, and safe for all genders. Now, ODR isn't just a tool, right? It's a lifeline for those facing gender-informed cyber disputes. If you look at online harassment and cyberbullying, imagine scrolling through social media and suddenly being bombarded with hateful messages. Now, with ODR, victims can swiftly report abuse through easy-to-use portals. And trained mediators can then step in to facilitate virtual sessions, helping victims confront their aggressors in a safe space. Take a look at revenge porn, for example. Discovering intimate images shared without consent can be devastating. Now, ODR offers dedicated portals to swiftly remove offending content, providing victims with legal guidance to seek justice and regain control of their privacy. Let's look at online discrimination and gender-based hate speech. In communities plagued by discriminatory remarks, ODR fosters accountability and dialogue. Now, victims can file complaints, sparking investigations and mediated discussions to confront perpetrators and reclaim digital spaces. We've also heard a lot of online dating disputes in the last few years, coming up of a lot of dating sites. And navigating disputes in the world of online dating can be very tricky. Now, ODR platforms provide neutral spaces for parties to voice concerns and find common ground, restoring trust in virtual connections. And let's also look at employment and workspace disputes. Now, in remote work settings, for example, gender-based discrimination can occur during virtual interactions. Now, ODR facilitates transparent communication between employers and employees, ensuring grievances are addressed with sensitivity and fairness. So basically, ultimately, ODR isn't merely a remedy. It's also a crucial support system for those affected by gender-informed cyber disputes, providing essential assistance and pathways for resolution in today's digital landscape. Next up, in the dynamic landscape of international relations, the convergence of global conventions and gender rights stands as a beacon of progress, guiding humanity towards equality and justice. Now, as we navigate the complexities of the digital age, these agreements remain pivotal in addressing gender-based discrimination and violence, both online and offline. Now, take for instance the CEDAW, right? It's a cornerstone in the pursuit of gender equality. Now, while not explicitly outlining online resolution mechanisms, Its provisions underscore the eradication of stereotypes and the promotion of women's rights, laying a solid foundation for addressing the challenges in cyberspace. Similarly, if you look at the Beijing Declaration Platform for Action, this is one from the 4th World Conference on Women. This recognizes the transformative potential of technology in advancing women's rights. Again, though not directly mentioning online resolution mechanisms, they emphasize bridging the digital gender gap and leveraging technology to combat online violence and harassment. Furthermore, if you look at the Istanbul Convention, this is a landmark treaty in combating gender-based violence, that too acknowledges the role of technology in perpetuating harm against women. Its provisions on cyber stalking and online harassment pave the way for comprehensive strategies to protect women in virtual spaces. Even the UN SDGs, for that matter, play a very crucial role. They also don't specifically mention online resolution mechanisms, but if you look at Goal 5, it targets gender equality and encourages the use of technology to promote women's rights, thus providing a roadmap for inclusive development in the digital age. Lastly, if you look at the Council of Europe Convention on Cybercrime, which is again not tailored specifically to women's issues, it does address various cyber-enabled offenses, including those targeting women. Now, its emphasis on international cooperation lays groundwork for effective online resolution mechanisms, thereby safeguarding women's rights in the cyberspace. So in conclusion, while all these conventions might not explicitly spotlight online resolution, their discerning provisions offer invaluable guidance for tackling such gender-based challenges in the online space. And by strategically applying these principles, policymakers and advocates can craft interventions to counter online gender-based violence, advance digital equity, and fortify the rights of women in the digital landscape. Next, let's delve into the constitutional safeguards that protect individuals, especially women, against gender-sensitive crimes in India. I'm not going to elaborate on this much, one, for positive time, and two, because all of us are very well versed with Article 14, 21, basically about the Golden Trinity,
I think you can,
and of course the IT Act.
You can proceed to sort of conclusion and suggestions.
Sure, absolutely. Now let's look at why we're looking at ODR as a preferred avenue for gender-informed cyber disputes. It comes with, it's a game changer when it comes to handling gender-informed cyber disputes. One, it gives you accessibility and convenience, right? Especially for those dealing with such gender-sensitive conflicts. Forget about the hassle of traditional courtrooms. These platforms allow you to seek resolution in the comfort of your own space without the need for physical presence. Next, we have empowerment and agency. Now, unlike traditional proceedings, ADR and ODR put individuals at the forefront of conflict resolution, and wherein the parties can voice their concerns and actively participate in finding solutions, empowering them to take the control of the process. Next, we have privacy and confidentiality, again self-explanatory, efficiency and expediency, and tailored solutions and preservation of relationships. So in a nutshell, choosing ADR and ODR for gender-informed cyber disputes is a smart move. They offer accessibility, empowerment, privacy, efficiency, and also ensure that everyone involved can navigate online conflicts with confidence and dignity. Now let's delve into strategies for effectively managing gender-informed cyber disputes through the lenses of ADR and ODR. Here are some pivotal recommendations that I think might optimize the efficacy of these methodologies. Now, specialized training programs wherein we can train mediators and arbitrators to handle the complexities of such disputes sensitively includes maybe understanding diverse gender identities and biases to create a safe space for resolution. Diverse panel representation might ensure building trust among the parties and acknowledge their perspectives, especially from a marginalized community. Technological safeguards like implementing robust technical measures on ODR platforms protects in terms of privacy and confidentiality, reassuring victims about data security. Community engagement initiatives. You can always launch initiatives to raise awareness about gender-informed disputes and promote access to ADR and ODR services through partnership with maybe advocacy groups and education institutions. Similarly, you have accessible support resources, victim-centered approaches, intersectional analysis, restorative justice practices, culturally relevant solutions, research and evaluation. So all of these recommendations basically allow us to create a more inclusive, accessible, and victim-centered approach to resolving gender-informed cyber disputes, fostering healing, empowerment, and justice in the digital realm. So I'm going to conclude with this now. We've thoroughly explored how ADR and ODR are crucial in handling gender-informed cyber disputes. Now, the recommendations that we've made aim to make these approaches more effective, inclusive, and responsive. We also highlighted the limitation of traditional legal processes in dealing with online harm, paving the way for victim-centered solutions. Now, the suggestions cover various aspects from specialized training for mediators to technological safeguards and community engagement initiatives. And despite challenges like systemic bias and evolving cyber threats, there's always room for optimism. Now, continuous learning, innovation, and collaboration can enhance ADR and ODR frameworks, making them more robust and equitable. We emphasize the importance of integrating restorative justice, leveraging technology, and adopting culturally responsible approaches. So ultimately, our goal is to create a digital society that prioritizes fairness, equity, and empowerment for everyone, regardless of gender identity or expression. Let's work together to build a safer and more compassionate online world. Thank you for being such an attentive audience.
I have a lot of questions. I'll be a little honest about that. So if you can go back to your there are two important slides. One, if you can, Renuka, can you go back to presenting your presentation?
Yeah, sure.
And there's a slide about sort of like advantages and what ODR is. Yeah, the one you just skipped. The one with, yeah, right. So if you look at this slide, if I can summarize what you're trying to say is that, right, there is a cyberspace. There are multiple conventions that say that, okay, in the cyberspace, there is a gender-based violence and there is tendency for cyberspaces being to cultivate gender-based violence and cyberbullying, etc., whatever you call it. To which your solution is, hey, but there is ODR. Now, this entire, am I correct to that extent?
Okay, so it's not, hey, but there is ODR. We also have ODR that we can look at. So it's not taking away from the existing framework of redress or the avenues for redressal. It is strengthening the existing mechanism by empowering the victim with the power of choice. So there's a reason I was using the word cyber dispute and not cyber crime throughout my presentation in most parts, because again, we are not dealing with rights in rem. In this aspect, we're dealing with rights in personam, wherein if you want to approach a court for any civil redress, instead of approaching a court through the traditional mechanism, you might receive a more efficacious response by ODR and ADR, is what we're trying to put forward. Again, we're not in any way taking away from the legal criminal system, because that's not how it works. You can't come to a woman and say, your videos are leaked, chalo, it's okay, go talk to your perpetrator and deal with it. That's not how it works. But if you're looking for civil redress, this is an additional avenue that the victims should be given a choice for additional redress. It's not taking away from what is existing.
Okay,
and the reason why ODR is also proposed is, if I may add, because the rules of evidence, we don't have the same threshold as, the standards of evidentiary admission is not the same as maybe Evidence Act, CPC and CRPC, because ADR does not succumb to that. So when the threshold for admissibility goes down so considerably, people are allowed to explore different kinds of proof and maybe get, expedite the process a little more and get good, quick justice. Because when you go through the traditional mechanism, everyone knows how much time it takes for one case to proceed. I mean, I'm not a practicing lawyer, but from what I've heard, at least, that it does take a lot of time. So while you are pursuing a criminal charge against somebody, if you're looking for civil redress, this is another avenue that should be available to you, is what we're trying to propose.
Okay, there are multiple tangents here, but part of what you said answered sort of half of my question, which is it's a parallel track, or it's an addition to what traditional sort of or all pre-established notions are. Again, there are multiple tangents here, but one of them is so when this presentation and this solution and this aspect goes more into a policy framework. The number one reason why policies fail in the world and in India are like two sides of the same coin. Lack of data, lots of assumptions, right? So when you say, and when the idea is that ODR is a solution, a parallel solution nonetheless, when ODR is a solution, hey, ODR is swift, it's sensitive, it's supportive, it's accessible. All of these are assumptions, right? Till the time, of course, these are assumptions which are probably not irrational, but these are assumptions nonetheless. From going from a traditional approach, from it being, when you're just juxtaposing, this is the sort of pre-established notion, and this is something that we are sort of trying to suggest. When you're making that jump from here to there or having a comparative framework, one would be to understand what are the lacunae that exists in the pre-existing setup, positives and negatives. I'm not saying this is a solution to that. I'm saying even if you say that this is in parallel to what ODR is parallel to what exists, there are still, why are there lacunae in part A, which are sort of being addressed in part B? That logical jump sort of needs to exist. That's one aspect of it. If it doesn't exist, that goes into an assumptive framework, saying that conceptually, ODR is here. It's A, B, C, D, E. Without going into the nitty-gritties of what A, B, C, D, E are, this lack of this jump will make it go into the more assumptive framework. Now, second aspect to that is, once you're saying that it's accessible, it's more private, it's empowered, it's centric. There are sort of rationale need to be given. Why is it so? What is a threshold for accessibility? What is a threshold for efficiency? I might be nitpicking here, but for it to be a relevant policy solution, these are the aspects that need to be considered, or else it just becomes a great idea. It's a startup. Startup, a million great ideas, but there's only sort of one Walmart, one Amazon, right? So, I mean, obviously that's an exaggerated example, but the point I'm trying to make it, for something to go from a concept to a policy suggestion, what needs to have is a rationale and data to back it, to whatever extent, indicative nonetheless. So that is something that I feel that ODR becomes very assumptive in this aspect. Will I be correct, or do you have differing views?
No, that's actually what I was looking at while I was doing my research. And again, because it's very explorative in nature, I couldn't find a lot of data for it. But then I do agree, I should also look into this a little more.
Yeah.
But yeah, I do agree with what you're saying.
Right. So what happens is, when you're lawyers and looking at a policy suggestion, this is something that we sometimes assume by ourselves. This was one of the things that, from when I went from a lawyer to a policymaker, this is the first challenge that I also faced, which is why I'm being little bit gritty about this, is because if you're suggesting a solution, you have to back it up. Even if it does not have data in numbers, it has to have some sort of an indicative analysis, at least a comparative analysis, saying that, hey, these are the number of cases. This is the reason why there's a large backlog. Therefore this is ineffective or inefficient. If you look at ODR, by concept, the framework does not need to have, say, infrastructure, and which is why it becomes more efficient to what exists, right? So you can also have a reasoning to that assumption. That's one aspect of things. Secondly, if you're pitching ODR only as a civil remedy, or sort of a civil action in civil consequences, not in criminal setup, then it has to be compared, has to be compared with like. So you need to explore what's the traditional setup when it comes to a civil remedy to a cyber incident. And then it can be a apple versus apple comparison. I'm not sure if that's how it's being compared right now.
No, that hasn't been explored, but yeah, that makes sense. We look into that as well.
Yeah. And the last aspect that comes to my mind is, if you say admissibility or admission or rules of evidence are a little lenient, or in traditional senses, in say ODR and ADR, the strict thresholds of Evidence Act is not applicable. That's a double-edged sword. While it can also be easy, or it can be a lot more, I won't say easy, but a lot more convenient for the affected person to present his or own case. At the same time, it can also make it a lot more easier for the perpetrator to say that, this is not true. So it is a double-edged sword that needs sort of, I believe, a little more in-depth analysis. If that's also an aspect that's being pitched. Either it's an analysis or it's a space where you sort of strengthen. That's how policy works. There's a problem, you problematize a situation, you find solution, you find unintended consequences, you fix unintended consequences, and you do the whole thing all over again. So probably if this presentation is moving more on a policy life cycle, a framework, you might have to address the questions and the issues here from a more policy centric framework. That's pretty much what I'm trying to suggest in a nutshell.
Yeah, got it. Absolutely.
Yeah. Okay, cool. I think I've nitpicked it a lot.
Hey, that was actually very helpful. Thank you, though.
Yeah, thank you, Renuka. I think Radhika, we can move to the next presentation.
Yes, so certainly. So that was the last name on the list for today. So I think we can circle back to the previous presentations. So we can begin with Shivangi's presentation whenever you're ready.
Yeah. Why don't you present the screen? I'll just...
Yeah, Shivangi. Yeah.
Yes.
My screen is visible?
Yes, it's visible.
Okay, thank you. Okay, so with the permission of the chair, I would like to start.
Please give me around 15-20 seconds.
Yeah, okay, sir.
Yeah, I think we can begin.
Okay, a very good afternoon to one and all present here. I, Shivangi Shimi, going to present on topic navigating the shadows, dissecting online harassment and cyberbullying impacting women in LGBTQ community. Let me introduce my topic. So, online harassment and cyberbullying refer to the use of digital communication tools such as the internet and social media platform to intentionally and repeatedly cause harm or distress to individual. These behaviors can take various forms and may target a person or a group based on their personal characteristics such as gender, sexual orientation, race, ethnicity, religion, or other attributes. If we talk about online harassment, it involves the use of digital communication channels to intimidate, threaten, or cause emotional distress to an individual or group. It encompasses a wide range of behavior, including but not limited to persistent and unwanted messages, trolling, and the dissemination of false information or malicious content. And on the other hand, cyberbullying is a specific form of online harassment characterized by the use of digital technology such as social media, email, or messaging app. Both online harassment and cyberbullying can manifest in various ways, including text-based harassment, image-based harassment, doxing, that is publishing private information, spreading rumors or false information. Moving forward, these are my research questions. So my first question is, what legal measures are currently in place to address online harassment and how effective are they in protecting the rights and safety of women and LGBTQ individuals? The finding of this question is India has numerous laws tackling online harassment, including the IPC and the IT Act. However, their effectiveness varies due to implementation challenge, resource constraint, and the ongoing debate between freedom of speech and the online safety. Women in LGBT community often face targeted harassment. Laws like Protection of Women Act exist their application in cyberbullying remains unclear. The second question is, what are the psychological consequences of online harassment on the mental health of women and LGBTQ? Um, to answer this question, studies show that online harassment has profound psychological consequences on the mental health of women and LGBTQ. Findings include increased level of anxiety, depression, stress, and feeling of isolation. With, if comparison with other group illustrate unique challenge faced by women due to targeted harassment. The third question is, what are the prevalent form of online harassment and cyberbullying affecting women and the LGBTQ? So there are various forms. Research find include the first one is sexist or homophobic comments. The second is doxing, revenge porn, and cyber stalking. Understanding the various forms is crucial for developing effective prevention and intervention studies. If we talk about the research methodology, so this research take a doctrinal approach, focusing on legal framework and their application to online harassment and cyberbullying. The third slide is about the contribution of my research. So the research on navigating the shadows, dissecting online harassment and cyberbullying impacting women and LGBTQ has the potential to make significant contribution across various domains. And the first is raising awareness and understanding. By delving deeper into the unique form of harassment faced by women and LGBTQ, this research can raise awareness about the specific challenges they encounter and dispel harmful stereotype. Also, identifying the psychological, social, and emotional impact of online harassment on these groups can highlight the severity of the issue and garner wider support for solution. The second contribution or utility of this research is identifying the legal gaps and inconsistencies. So, doctrinal analysis can pinpoint areas where existing laws short in protecting women and LGBTQ individuals from online harassment, informing legitimate legislative reforms and legal advocacy efforts. This research can recommend effective legal, technological, and social intervention based on data and comparative analysis, guiding policymakers and advocates in their work. The third one is fostering social change, which means by critically examining the social and cultural factor contributing to online harassment, this research can challenge gender and sexuality-based discrimination, promoting inclusivity and respect online by empowering individuals and communities through documenting copy mechanism and support system utilized by individuals and communities can empower others to navigate online harassment effectively and build resilience. Uh, these are the findings of my research. The first one is women face more sexual harassment, doxing, and stalking as compared to men, and same with the LGBTQ individuals. They face harassment targeting their sexual orientation, gender identity, or other aspects. Next is if we talk about the impact, the first impact is psychological impact, which include anxiety, depression, lower self-esteem, fear of using online platform. If we talk about social impact, then it includes withdrawal from online community, isolation, damaged relationship. And if we talk about emotional impact, it includes anger, fear, sadness, and loss of trust in other. Also increased risk of self-harm or suicidal ideation. Um, Next is the finding on the suggestion. Researcher has some suggestions. There is a need of a strengthening legal framework which addressing gap in legislation, that is the current legislation, and ensuring its effective enforcement. Second, by developing platform-specific solution which include filtering technology, reporting mechanism, and educational initiative. And the third one is empowering individuals and communities through providing resources and training to empower people to identify, report, and navigate online harassment. That's it. Thank you, sir.
Thank you so much. Can you take sort of briefly explain what are the sort of gaps that exists apart from strengthening legal frameworks? For example, why do you say developing platform specific solutions is important?
Yes, sir. Sir, if we talk about the strengthening legal framework, it includes there is a gap in legislation. Like for child, there is a specific act POSCO, but for women, if she's suffering from cyber harassment or bullying, of course we have IT Act, but there is no specific mention for this. There we have a Sexual Harassment Act, we have Domestic Violence Act. Of course, there is Section 67 in IT Act, which talks about transmission and publication of scene act. But still, there is not clarity for online harassment type things. That's it, sir.
Sure. Okay. Thank you so much.
Okay, thank you,
We
sir.
can, Ritika, we can maybe move on. I guess there's one person remaining.
Yes, sir. The last person remaining is Chanpreet Kaur.
Yeah, you can probably set up the presentation.
Yes, just a minute, please. Okay, is the slideshow visible?
Yes, it's visible.
Okay. Okay, good afternoon, everyone. So the topic I'll be speaking on is making safe online spaces a reality, the importance of defining digital rights of the LGBTQ community. So I'm Shanpreet Kaur, and currently I'm an assistant professor at Amity University, Amity Law School, Kolkata. And as such, I specialize in human rights, so I've tried to give it a human rights perspective. So basically, digital rights are something that have come into being in recent times, because earlier the entire regime of human rights was of course focused on certain basic things, right to life, right to personal liberty, and so on. So digital rights are in fact a representation of the same rights. So having the right to life means having the right to privacy, as is spoken about a lot in the Indian context as well. And the freedom of speech and expression also includes the right to express yourself freely on the internet. So these digital rights, as such, have not been defined anywhere, but we can include multiple things within these rights. First would be the right to be informed, wherein you're supposed to be informed about the data that you're posting online, that how is it going to be used, is it going to be collected, how is it going to be published, and how is that particular internet provider going to deal with that data per se. Then there is the right to access. That is that you should have a right to access the information, that how is your data being used by that particular organization. Almost you can relate it to the right to information, that these organizations should also provide you with the terms and conditions that are there for you using that particular website. Then there is the right to rectification, that if there is any wrongful data about you that is being presented online, if you request for the same, that said data can be rectified. Then right to be forgotten is a very important right that has come up nowadays. It simply means that something that you post online should simply be removed if you ask for it. Right? This is a right that is highly debated, because most things always exist on the internet once you've put them there. Then of course, the internet provider is supposed to ask for your consent whenever any new sets of rights or liabilities are being developed in their terms and conditions. And of course, the right to be protected against online bullying. Now, as we all know, the LGBT community is one which has thoroughly used their online rights or digital rights for propagation of their own ideals, for what they require, for what rights should be given to them, and so on. Just like recently, when the judgment came out regarding LGBTQ marriage, or even with regards to removal of Section 377, the internet was used for sharing views, giving information, and so on. So it's an important tool that is available with the LGBTQ community. If we look at it, they have used it for forwarding their own rights. The only problem with it is that internationally, there are the Yogyakarta principles that came out in 2016 that deal with what rights should be given to members of the LGBTQ
LGBTQ community. But other than that, we are not specifically talking about LGBT anywhere. It is almost like a interpretation of your right to life again, and your freedom of expression, your right to self-determination, and your right to development that is promised under various rights, various documents like the UDHR, ICCPR, and so on. So, therefore, if we have digital rights of the LGBTQ community, it essentially acts as an empowering tool for them, where they can share information with each other, where they can come out with their own gender identity, and it also helps them build a community. So, the LGBT communities are perhaps one of the most strongest ones on the internet, wherein they support each other. Of course, they can share information because this is still a highly developing subject, the concept of gender, the concept of LGBT rights, and so on. So they can also share information regarding healthcare issues. So of course, it is not what the doctor prescribes per se, but the LGBTQ population who may be going through a gender reassignment surgery or any such other things, they may be taking hormone therapy. It provides them a good platform where they can share their experiences with each other. And last but not the least, as I've mentioned, that it helps strengthen their political claims. This means that uh, they can voice their opinion simply. See, the important thing here to note that is that digital rights actually come quite later on. The first and foremost thing that is important here is that they don't have the basic rights only. In some countries, they may not be recognized. In some countries, being gay or being lesbian or a member of this community may be entirely prohibited, where it may be illegal. So, digital rights actually come much later on, but they need to be promised because if everybody is given similar digital rights, that would mean that they have a right to freely voice their opinion in their community. Okay. Now, there are many issues with LGBTQ community and the internet. Most of these relate to the terms and conditions that are specified. So, mostly the community guidelines that are there for these organizations. As you know, first of all, I've stated that the first issue is that there's monopoly. Instagram and so on, they have monopoly in the social networking arena. So everybody will go on Facebook, Instagram, and so on. So everybody has to comply with their guidelines. If they don't comply, then they essentially will have to leave that network. So they try not to upset it and try to follow the guidelines that are there. Now, other issues are with community guidelines. So in 2018, a major thing happened with Facebook was that they altered their terms and conditions of use, the community guidelines, and stated that you cannot solicit, you cannot basically engage in prostitution on Facebook and so on. So this means that you cannot basically state your sexual identity also. So at that time, if you look up the terms and conditions that are usually mentioned in the community guidelines, they have an explanation attached to them. So the explanation also meant that you cannot state things like I am gay or I am lesbian or even I'm straight for that matter, because the community guidelines may construe that you're trying to solicit there by stating such things. So therefore, usage of the simple terminology that I'm gay, bisexual, transsexual, or lesbian became a thing where you're trying to solicit sexual favors from another person, and it was not allowed by them. Then, even right now, you can go and look up the real name policy of Facebook that is there. So, according to the real name policy, there is a policy that you are supposed to use your real name. They don't allow you to use characters and so on in the name, but also they state that the name that you're using must be one with which you're referred to in your community. So, as such, this provision has not been abused so much that they have removed people. But the thing is that it may be abused in the future. Uh, So therefore, actually having a pseudonym or having an alias that you're using on Facebook or Instagram is very important for the LGBT community, because it allows them to take that veil over themselves, and basically in areas where their society may remove them if they find out that they are belonging to this community. It acts as an effective tool where they can remain online also, while they can have some sense of anonymity also. Then, of course, bullying and so on. So, one of the important things here is that there's lack of research in the field. So, nowadays, there's a lot of talk about multiculturalism. So, related to multiculturalism is this issue as well, that you should allow the people to come forward. In feminism, it's a very important tool of research, asking the women question. So here also that tool can be applied, asking the LGBTQ question, that how is the policy going to impact the LGBTQ community? So building upon that, I don't know how much time I have left, but I'll try to wind it up. So therefore the
I think you're the
issues
last
are
speaker, so you can sort of push forward if there's no problem.
Okay, thank you. Okay. So first of all, of course, on a substantive level, as I've mentioned, that the LGBT community is not able to exercise their rights to the full extent. So the freedom of speech and expression may be controlled because of these reasons. Nowadays, various apps have come out with some technologies. For example, Grinder, which is an app which deals specifically with the gay community. What they do is that they have the logo is different. So essentially, if somebody looks at your phone or sees your phone, they will not be able to see that you're using Grindr. So that gives them some sort of an anonymity and allows them to exercise their rights to the full extent. Then, of course, on a policy making level. Now, if you're not recognizing LGBT rights at all, you will, of course, not be able to form policy for them also. So actually, there needs to be an organization or probably a fact-finding commission that needs to be set up to look at the LGBT community, what is happening in their lives, what sort of rights would they need, and what are their specific problems. Again, a continuation of the asking the woman question. And then, of course, conducting research on these issues. Now, here I've also spoken about technology. So, technology is not equal. So most of the technology that is built currently and most of the apps that are built, they may be in support of certain regimes. For example, the stand on LGBTQ rights was very different during the Obama regime versus the Bush administration. Now I think it's a continuation with Biden. So it's a more like a liberal approach. But governments may be able to impact the policy that there is, and thereby technology also becomes in a way it acts against the LGBTQ community. So there needs to be a uniform technology that the technology that they're using is promising equal rights to LGBT, keeping in mind their experience while they are giving the same rights to the straight population as well. Okay. So basically, another issue that comes in is that the issue of cyberbullying. But that's a completely different thing that applies to both straight as well as LGBT, where a person is located someplace and the act is taking place somewhere else. So that issue of jurisdiction also becomes a problem here, because mostly people post online regarding their identity and then they get bullied, and then as a result of that there have been suicides as well. So how to curb that issue is a problem. Okay, so now in support of my argument that there needs to be special LGBTQ rights, I have mentioned this. The Special Rapporteur on Promotion of Right to Freedom of Opinion and Expression has included that the digital rights should be a part of the human rights. So therefore, they have stated that the internet is a very important part through which self-actualization takes place, self-realization takes place, and where you're able to exercise your freedom of speech and expression. Therefore, rights relating to the environment relating to the internet need to be promised. Then there is the Special Rapporteur on Promotion and Protection of Human Rights and Fundamental Freedoms while countering terrorism. So although this relates to terrorism, but still, here it is spoken about, the right to privacy is spoken about, which we can relate to the right to be forgotten and so on. And it states that the right to privacy is therefore not only a fundamental human right, but also a human right that supports other human rights and forms the basis of any democratic society. So now, what will be the resolutions are? This is an area that I've newly started researching. So I think actual proper resolutions I'll be able to further develop on. But it is basically that the policy should be LGBT centric. So therefore, there need to be stakeholders in the policy making process from the community. Now, as far as any government office is concerned, or there are very few spaces, even many national law schools, where even faculty or students may not be able to come out and speak, right? These are very important think tanks also, but they may not be able to voice their opinion being an LGBT person. So therefore, there needs to be more people who come out and who effectively give their take on a certain policy. That would mean institutional protection as well. Then increasing their participation in technology design debates. Understanding that where does the problem lie, that when the LGBT community is interacting with the internet, what are the issues they are facing. So again, relating to anonymity, relating to the right to be forgotten, relating to privacy issues. And of course here I would take a very strict policy towards freedom of speech and expressions and the right to life, that a person should be able to exercise their rights freely. You know, it's almost like me saying that right to surrogacy should be available to every person, because a female should be able to provide surrogacy services if she is exercising her rights completely. The state should be completely exempt from it. So here also the state should be completely exempt from what the LGBT community is doing. And so therefore, if they are voicing themselves on the internet by using certain sexual innuendo, etc., it should be allowed in a way that community guidelines are there. But again, here you should ensure that the 18 plus the children below 18 stay outside of the social networking sites. And finally, having a global framework wherein we are able to have an authority that keeps a check. So nowadays, I think you were referring to the Data Protection Act also that has recently come out. It is speaking about the service providers. It is speaking about the data principals, who are the ones who actually own the data. But keeping that in mind, what we are like, so therefore we are recognizing that these Facebook, Instagram, and all of these entities do have certain liabilities and duties that they owe by imposing multiple fines on them. Uh, but I think there needs to be more of a check on these authorities in order to ensure that an organization or a person which is located in another country, how we are going to treat them. So this is all I would like to conclude here. Thank you.
Thank you so much, Professor. This is actually an area I really research in and I sort of personally work in. For example, DPDPA is a step forward because the right to rectify, right to forget, right to change is statutorily incorporated, which has to be sort of acceded to. So a large part of what you sought to cover, though it is not the intended sort of societal target group to for which rights are being developed. By extension, it covers everybody, including the LGBTI community, right? So that's how law has already developed. We are sort of waiting for things to be implemented. I, on a day-to-day basis, is working with organizations to sort of get this implemented on the tech side of things. So this is something that I can say as somebody who works with tech teams, is irrespective of what gender is, the law, since the law makes it a point to make sure that there's a right to change, right to rectify, and right to forget, it's being incorporated into, I mean, obviously we are at an extreme nascent stage of implementation of DPDPA, but as a first-hand information, this is happening. So this is going to be very interesting to see how digital rights develop in this context. while at the while that is happening, a lot of what you're sort of researching on is covered, is sort of gets covered by these two really cool organizations, which I love to follow. One is called the Rebooting Social Media. It's by BKC, Berkman Klein Center at Harvard, and Yale has also a research center on social media or rebooting social media, something like that. So these two organizations actively work in this area. They have a lot of research on exactly what you're trying to say. Since they are US based, they do cover policy, law, and governance with changing presidential terms. So that's probably where you could start off with if you seeing sort of seeing if you're developing here.
Yes,
It's
yes.
also an interesting area called digital constitutionalism, which I really like to read. There are only two books on it. So by one author, which I can't, one Italian guy. So
Digital
all of this sort of fills in that domain, which is really unexplored in our country. Uh, Not necessarily to be seen in the context of LGBT rights, but in general, the evolution of digital rights or rights in the digital age, however you look at that. But the positive consequence of that is that it empowers a marginalized community, or it empowers a minority community, or it empowers a LGBTI, or it empowers any certain individual, irrespective of how we look at it. So probably that's something you could explore. But yeah, I mean, I found it to be at a stage where it's very conceptual, but can be sort of gone into deeper, if
All
if
right.
I could say that.
No, this is a very interesting thing. I would like to.
Yeah.
Thank you so much.
I don't per se have any questions.
Okay. Thank you so much.
Thank you.
Thank you.
I think, Ritika, are we done with all presenters?
Yes, so like Anushri Saha was left, but she has still not joined the meeting. So we'll be concluding with the presentations for today.
Sounds great.
Yeah. Thank you so much, sir,
Thank you.
for your expertise today.
Yeah, thank you so much. Thank you, all participants. It was lovely. It is after a long time I did get a chance to go back to things that I really like exploring and working with. On the chat box, I'm just going to drop my email ID. If anybody wants to get in touch with me, I'm sure you can drop me an email, or send me a request on LinkedIn. I'm pretty active there, so I'll be very happy to connect with everybody. Everybody here has been doing this for a much longer, larger time than I have been doing. So it was sort of a learning curve for me as well, and I really, really like being here. So thank you, organizing committee, for having me here.
Thank you so much, sir. I'd also like to thank all the participants who have shared their presentations with us today. And at this point, I'd like the participants to make a note of the fact that it is mandatory for them to attend the valedictory ceremony as well. And attendance will be marked for the same. Thank you so much, everyone, for your cooperation and your insights.
Thank you, everyone.
Thank you. Ritika, we can end the meet, right?
Yes, I believe we can.
Thank you.
Thank you.